Thank you for evaluating Texas Youth and Government Appeals Court. We're so grateful that you're here. All the students you will be evaluating today are high school students from across the state of Texas. In order to qualify for state competition, teams have to rank high enough in their district, and judges and attorneys have to pass an exam which will test their knowledge of the law. In order to be the best possible evaluator, it is important to remain unbiased throughout the day and to be consistent and careful in your evaluations and critiques. Let's begin with appellate attorneys. They are scored on a 1 to 5 point scale. They are scored on knowledge and use of facts, knowledge and use of case law, their effectiveness and persuasiveness throughout the trial, their ability to respond to questions, and their demeanor and presentation throughout the trial. Here is an example of a good attorney.
May it please the court. My name is Amy McNichol, and this is my co-counsel, Jerry Velasquez, and we represent the appellant in this case, Jimmy Smith. In my time before the court, I will demonstrate that the trial court abused its discretion by refusing to suppress the statement made by the appellant to the police. My co-counsel will demonstrate that the trial court abused its discretion in certifying the appellant as an adult. Your Honor, would you like a brief statement of the facts?
No, please continue.
There are two issues I will address. First, the police used deceptive tactics to obtain the appellant's confession while she was under mental duress. Second, statements elicited by the appellant were taken in violation of the Miranda warning requirements of Section 51.095 of the Texas Family Code.
This attorney was clear, fluid, and informative throughout his introduction. He made sure to ask the justices if they wanted a brief statement of the fact as he introduced his points. Here's an example of what a poor attorney might look like.
May it please the court, we represent the appellant. We are here to prove that the trial was wrong in its decision and the appellant's statements were illegally taken and that she should have been tried as a minor. I will discuss how these statements were illegally taken.
This introduction was not fluid or well thought out. The attorney did not introduce his points or ask the judges if they wanted a brief statement of the fact. Here's an example of an attorney making a good argument.
After being arrested, Ginny Smith was taken back to the police station and read her rights. The Texas Family Code, Section 51.095, states that confession of a minor must be signed in the presence of a magistrate by the child with no law enforcement officer or prosecuting attorney present. However, according to the record, Detective Hodges, Officer Murray, and Officer Court were present when the appellant signed her confession. This is in violation of the Texas Family Code and is a cause for retrial.
Excuse me, but doesn't the Texas Family Code also state that the magistrate can have officers in the room if the magistrate feels threatened?
It does state that, Your Honor, but Officer Court described the appellant as calm and lucid. It is not likely that the magistrate was afraid of a calm and lucid 15-year-old girl. Even if the magistrate was afraid, it would not be necessary to have 3 law enforcement officers present.
You may continue.
For these reasons, I pray that the appellant court will suppress the statements made by the appellant and give her a new trial. Thank you.
This attorney properly used case facts and case law to prove his points, and he answered the judge's questions. He also used a respectful prayer to conclude the court. Here's an example of a poor argument.
Officer Court took advantage of Ginny Smith's poor mental condition. She had been through a long day of questions and was not in her right mind when she made her statements. She was also under the influence of Prozac, which also influenced Smith's decisions that day.
Excuse me? Officer Court described the appellant as calm, lucid, and collected. And Smith was informed of her rights and willingly waived them to confess. Due to these facts and decisions, why should we believe that the appellant was under mental duress?
Because she was on Prozac.
This attorney used no case law to support his argument and employed speculative rhetoric, not evidence, to try to prove a point. When the judge asked him a question, he lost his rhythm and made a poor answer. A good appellate attorney should be fluid in his arguments. He addresses the court, presents his points, and makes a good argument while respectively concluding. He keeps good eye contact with the justices and is confident and persuasive throughout the judge's questionings. He answers the judge's questions to the best he can. A great attorney answers the questions with case law and uses that question as a chance to better his argument. They base their arguments on case law or case facts, not evidence or speculation. Each attorney should have an argument with at least 2 points that they are able to defend. In scoring, it is important that evaluators give points to the attorneys on the same scale, so it is not advised to give all 5s on their score sheet. It is best to score them 3s or 4s unless they are faultless in a certain aspect. Next up is appellate justices. Appellate justices are scored on the same 1 to 5 scale. They are scored on their knowledge of legal procedure, their ability to communicate grounds for decisions, their questioning skills, their reasoning ability, their knowledge of the law, their knowledge of facts, their demeanor, and also their cooperation with judicial colleagues. Here's an example of a good justice performance.
Officer Court took advantage of Ginny Smith's poor mental condition. She had been through a long day of questions and was not in her right mind when she made her statements. She was also under the influence of Prozac, which also influenced Smith's decisions that day.
Excuse me. Officer Court described the appellate as calm, lucid, and collected, and Smith was informed of her rights and willingly waived them to confess. Due to these facts and decisions, why should we believe that the appellate was under mental duress and coerced by Officer Court?
Because she is on Prozac, and Officer Court said that she would go to bat for the appellant if she would only confess.
Did Officer Court or any other officer ever admit to saying such things to the appellate?
No.
In Espinoza versus State, it held that simply encouraging a suspect to give a statement does not constitute a promise. In this case, Court admits to encouraging the appellate to confess, but never admits to making any promises. Because of the ruling in Espinoza, what reason does the Court have for ruling the statement involuntarily?
This justice appropriately used his knowledge of the case and knowledge of other case law to challenge the attorney's argument. Here's an example of a poor justice.
Officer Court took advantage of Ginny Smith's poor mental condition. She had been through a long day of questions and was not in her right mind when she made her statements. She was also under the influence of Prozac, which influenced Smith's decisions that day.
Excuse me? How could all these factors cause the appellate to be under mental distress?
All these things took heavy tolls on Ginny, and Officer Court took advantage of them and coerced them into giving her a statement.
Thank you. You may continue.
This justice asked a question with no direction or substance. It did little to challenge the attorney's argument and was useless. Usually, a poor justice is one who asks no questions and or appears to have no knowledge or understanding of the case. Good justices make eye contact with the attorneys and ask at least 3 questions to each attorney. Questions should be about the case law, the facts of the case, and reasoning. Judges should not be argumentative, but they do need to challenge the attorney's argument. Judges should be confident and clear. The trial should be sort of like a conversation between the attorneys and the justices. While the attorneys make their points, the judges should interrupt them and ask important questions. It is advised that the evaluators grade the judges very strictly this year, as their performance can determine the outcome of the trial. Your evaluations should be based on the performance of each of the participants, not the facts of the case itself. You will be provided with an evaluator's rubric, which will allow you to rate the participants on a scale of 1 to 5. After the conclusion of the round, you are welcome to offer comments to the participants, letting them know where you felt they performed well and how you think they can perform better for the next round. Your comments and suggestions are not only helpful to the participants as a learning experience, but appreciated as well. Thank you again for evaluating Texas Appeals Court.